Welcome to the Buying Legal Counsel Legal Procurement Best Practices call. Our expert today is Toby Brown. He will talk about introducing standards for matter coding. Toby, we're really excited to learn about this today. Thank you so much for being here.
And thank you for having me. This is a topic that I think is very important and very compelling, so we appreciate the opportunity to share this with your group. And just very briefly on me, I'm Toby Brown, obviously, but I'm the Chief Practice Management Officer at Perkins Coie, and why that might be important to this conversation is one of the functions I oversee and I'm very involved in is pricing. So that will likely come up as we walk through this material. So what we want to do is give you a little background on what we're talking about and how it all came about and why we, and ultimately end up why we think it's important to you. So the SALI Alliance, and SALI stands for Standards Advancements for the Legal Industry. It's an independent organization, and it brings together important stakeholders like law firms, clients, solution providers, and the goal is to develop open, practical standards for the legal industry. And we're going to get into why that's important, but at the very top level, most industries, many, some, you might even say all industries have some level of a standardization or standard setting body. Legal, we've had sort of pockets of standards that have created. So this is really the first industry-wide standards effort. The matter type standard is the initial standard we're looking at, but we see this as a long-term benefit to the industry. So the mission is actually very broad and very important. Who we are, and I've sort of alluded to it already, the stakeholders. The best standards come about when it's not driven by one segment of the market. And so, the various segments of the market we're talking about here, obviously, your procurement group, the buyers of legal services, and then the providers, law firms, and even, alternative service providers, the technology and solution providers. If the technology can't support a standard, obviously it won't work. So it has to serve the needs of all of those. And then finally, associations and academics, they sort of represent broad swaths of the industry. So they're very important to this. So what are the goals? Number one, a standard has to be freely open and available to all stakeholders. If a standard becomes something that is owned or driven by one set of stakeholders, typically it ends up being the providers, the technology providers a lot of times, then it's very useful for them, not as useful for everybody else. And if it's not as useful for everybody else, or if it's not freely available, then it really doesn't become adopted as a standard. Having an independent, objective third party, a nonprofit run it is very important. That gives it that independence and that, again, adaptability by the industry. The standard needs to be thoughtful in how it is structured. The hierarchical comment there, it needs to be extensible, which is to say a standard can't solve all problems for everyone. So it needs to be designed in a way that different groups can extend it so that it meets their needs. And kind of, although it's mentioned last here at the very, I'll put it at the top of the heap, it needs to be practical. It needs to be something that works in practice. So starting off, I mentioned that SALI starting off with legal matter specification as an initial standard. And it's really about providing, as noted here, a common vocabulary such that terms are commonly understood between everyone in the industry. And this sounds very simple, and you're like, oh, well, everybody understands, single plaintiff employment litigation. Maybe they do and maybe they don't, but that's just one example. We need to find ways to structure how we refer to those things and how we describe them in a common way so that when, for instance, a client says, I want a law firm or a set of law firms to give me a proposal on type X of work, they get similar responses from all the law firms involved. We like to show this example to start to demonstrate what we mean, because you could just say, oh, a nail is a nail is a nail. There is actually as you can see here, a somewhat complicated standard that describes, and it's the SKU. When you buy a nail, as you all know, when they scan things, they're essentially looking for the SKU. It says here are the the categories or the explainers, that's not the best term, but the factors that describe this nail. Tells you the length, the diameter, the type of head on it, all types of things like that. And you might think, oh, it's simple, but once you get into standards, you'll see that they are everywhere. So where we're headed with the standard, and we'll talk about the timeline here in a little bit, is something very similar. So what you're seeing is the same sort of SKU here for a type of labor case, labor and employment, wage, and class action. You see area of law, the type of product, the jurisdiction, the type of parties involved. This is where we're trying to get, so that when this set of codes are used for for law firms, for clients, and the technology that supports it, everyone knows what they mean, and systems can manage these data points, between, say, an e-billing system and a law firm's practice management system, those sorts of things that will allow data to flow freely between all those systems. This is an example of why this is hard. A lot of times when people hear about standards, like, oh, you should be able to get together in an afternoon and decide this. It's a little more difficult than that. In fact, I'll tell actually a slightly different example here. I was involved in a standards effort a number of years ago. It was called Legal XML, and we developed the standard for court filings. So as you're doing court filings, it's an XML data standard that gets used in the background. That was developed by Legal XML like 18 years ago. In one of our standard setting meetings, we spent an entire afternoon arguing, or I'll say discussing, the data field name. And you might say, well, that's really easy, first name, middle name, last name. Some systems had 5 different fields for name. Some systems had 1 field for name. So there was this very protracted and heated discussion about what the standard should reflect when it comes to name. That's just an example of why this is difficult. You have to really get the buy-in from the audience. You have to have all the stakeholders say, well, this is what it means to me, and this is what it means to me, and then come up with a way of normalizing that so that it makes sense for everyone. I like this example because it talks about through a life cycle, and this happens all the time on a law firm side, where there may be a matter is opened initially and it's sort of consultation around a transaction, then it becomes something more involved, and then ultimately it might become an M&A deal. So you want a standard that allows that evolution through the life cycle of a matter. And this, again, this gets back to our nail, but it's metal. It's a metal, round, broad, and then it's a nail. But each of those build upon the other. How is this data used? Obviously, there's a lot of value propositions around this. It's common ways of, describing it from a law firm side or from a client side. I mentioned pricing was in my wheelhouse. It's, if we want to price something, we want to know that we're pricing the same thing each time. There's just a lot of value propositions. For the client side, when I've talked with clients on this, in-house legal teams, once they sort of get the intent and the goals around this, they're like, wait a minute, this will be awesome, because then when we put a matter out, an engagement out for bid, we'll get 5 very similar bids instead of 5 very dissimilar bids. Another challenge here that we like to point out, viewer invariance. We need viewer independent descriptors, because as I'm sure like on a litigation, law firms in our system will have plaintiff and defendant. But in our conflict system, it'll say client and adverse party. So you have to translate this into all of those neutral terms so they're viewer independent. Again, this takes a bit of time to come to agreement on what makes the most sense. Here's another great, I love this example because it's very applied. Instead of saying turn left, it's saying turn west, because everyone can agree on what west is, but left depends on your perspective and which way you happen to be facing at the time you get an instruction. So the value of this, I've already suggested some things, but here, value to the client, more reliable data for decision making, so that over time once you have a standardized way of describing things in your own systems over time, okay, this was always type X, so we can go back and look at type X and see what data we now can compile around that. And it will be data that you can compare against the market, not just internally. That, of course, will allow for more effective and efficient fee discussions. And this is a very important point from my perspective, enhanced alignment between client and firm. Because if you both understand something in the same way, it will allow the client and the firm to really come up with pricing and delivery approaches that all align and are win-win for everybody. And that even goes to the fourth point. It's really allows for better collaboration. So what is the standard? Where is the standard right now? We've come up with a standard structure for how we describe a matter, and I'll show kind of a high-level example here in a moment. A standard vocabulary, and those are the codes that we talked about. And then we're also, as an additional aspect of that, setting up standard tools, which are types of APIs that will allow any data structured in a standard to be passed from system to system to system in a very efficient way. And that can be within a client set of systems, or within a law firm set of systems, or best case across clients and law firms. This screen looks very complicated, and I like to show it because it also shows this is not easy. You have to think about a lot of things, and there's a lot of dependencies. But I wouldn't go in the weeds on this, but just to get a sense of the the 30,000-foot view of the standard. Here are some examples. You can see the code sets, but I want to move to this screen. This is actually a tool that we have up on the SALI website that you can go in and play with to get an idea of what we're talking about with the standard. So on the left-hand side of the screen, the box is there. The box in the middle that starts with A-advisory, those are the top 5 level categories for types of legal work. Advisory, disputes, and disputes is a great one to stop on because you'd say, oh, that's litigation. Well, disputes can be mediation, arbitration, it can be administrative litigation, other things like that. So disputes is the more neutral global term. So we have advisory, dispute, bankruptcy and restructuring, which that one there was quite a bit of dialogue around, but we ultimately decided it was a unique enough type of practice because it's an odd blend of litigation and transactional work that it got its own high level category, then regulatory and transactional. So you see in this example that we've selected transaction. So then you see the next level of the hierarchy, and you see development, financing, formation, lease, and license. There's a few more on that list, but because we've picked lease, you see that now to the right, the code for this would be T-LEA for transaction lease. You see that the name is lease, and I know this is somewhat obvious, but then in the description, this is the common vocabulary of what the proposed draft standard is for what it means to be a lease. So as we're developing the standard, we're having to go to each of these and say, okay, for transactional work, what is the universe of next level? And then come up with common descriptions, commonly understood descriptions that will make sense to clients and law firms across the board, and that, again, all the technologies can support this. So this is a very important screen to really help describe or demonstrate how the standard will look and function. We're using an agile process for how we're developing the standard, where someone might propose a new aspect of the standard, comment testing, and then we come to agreement. This is, I'll say, bread and butter for how standards are developed regardless of the industry. So let's talk about timing. Turning the clock back a little bit, the way SALI came into being is a few years back at an association meeting. It was actually the ILTA association meeting. We convened, I call it an exploratory meeting, and it included all the stakeholders, clients, in-house legal departments. Well, they are the same, but law firms, technology providers, and actually some consultants as well, and a couple of associations, ILTA obviously, but the LMA was there as well at the initial meeting. We talked about the viability of this and what it should look like. And ultimately what we decided is we needed to form an independent entity, because having any, as I mentioned earlier, having any one segment of the industry try to own this would limit its success or handicap its success. So we decided that was the way to go. So earlier this year, we stood up the organization, opened it up for membership, then started moving forward. And we'd actually had some preliminary, I'll say, discussions. And one of the reasons, another value for having an independent organization revolves or centers on intellectual property, because when you participate in a standard, you're essentially contributing intellectual property to the standard. And you need an intellectual property framework that allows people to participate without them effectively giving their intellectual property away to competitors and others. And this actually applies to law firms and in-house legal departments, but it especially applies to the technology providers and other vendors like that. So you needed a framework and a set of protections to say, if you contribute to this, you need to know it's going to become part of an open standard available to everybody for free. But you also need to know you're not handing your IP over to somebody else. So we got all of that in place. But prior to that, we had actually had some conversations about what we thought the structure of the standard should be. So we had, I'll call it a running start. Since then, we've had a number of meetings. We met again, and we try to piggyback our meetings around known conferences. The ILTA conference is one that has worked well. The P3 conference is another one we tend to meet at. We like to have in-person meetings when we can, because that allows for more robust dialogue around the issues. So where are we now? What we're looking to do, and the goal is, and I think we're on track to get there, would be to release a draft specification of what will be version 1.0 of the standard at Legal Week in New York in late January, which is a convenient conference, we'll call it, where people are generally going to be there anyway. So we'll do an in-person meeting then and finalize the draft. Now, it's called draft very, very purposely. Once we have our draft specification ready to go, then we're looking for 2 or 3 reference implementations. And this goes to the point about the standard being practical. We're looking for some reference implementations where organizations take the standard and put it into play within their own systems. Then part of the way the standard works is once you're a member and you're participating, that you give feedback to the standards group about what works and what doesn't work. And so with those reference implementations, they'll come back and say, okay, in practice, this worked great. There were some challenges in this area, and give that feedback. So then we then take that feedback and release a published standard, which that's dependent on the reference implementations. We're hoping that by August, which would be the next ILTA meeting, we could release a full specification published standard by then, but it will depend on the reference implementations. And to give you an idea, the 2 that have stepped up and said they want to do reference implementations are Greenberg Traurig, the law firm, and Microsoft's legal department. And the beauty of that is Microsoft is a client of Greenberg, so it could end up being like a 3 for 2 sort of thing to see how that works out. So we're very excited about that, but that kind of gives you an idea of the timeline around this. This gives more detail on what's underneath that, and when we're talking about where we are in the process, where we are right now, shooting for that January date to have the draft ready. So how do you get involved? And I highly recommend, and you might be saying to yourself, what is the value of getting involved? I sort of see at the top level, there are 2 high-level values. One is, first of all, demonstrating that you and your organization are on the front edge of of innovation in the legal market. And I definitely think there's value to that for clients, for in-house legal departments, obviously for law firms as well. The other is to help drive a standard that you know is going to work for you, and which is good, because if it works for a number of clients, hopefully many clients will get involved, then it will work. And so it's driving a standard that will work within your organization. And that's generally the tension when you're having standards discussions is, it's more on the vendor side, where their current technology supports a specific approach, for vendor number one, and vendor number two has a slightly different approach. And so there'll be some discussion over how we normalize between those two different approaches. So that occurs between law firms and between in-house legal departments. So there are good reasons for you to get involved. How you get involved, obviously having technical people, and I can tell you, because my firm is a member and actively involved, obviously. My role is president of the board of SALI, so I actually am more involved on getting people involved, driving the organization, but then somebody else from Perkins Coie is involved on the technical side. And that seems to happen a lot with organizations once they become involved. But this gives you some idea of where specifically you might get involved. A question I get frequently, I'll actually leave it on this screen, beyond how do I get involved and what are the ways that people can participate and be part of the success of this, is related to an existing standard, and how does what the SALI matter type standard interact with the elephant in the room, task codes? That's a good question. We actually have liaison relationships with I'll say, various task code groups. And at this point, we see what we're doing as a complement, because task codes are more at the sort of, I'll say, detail, in the weeds level, and we're up more at the general level, describing, I'll say, products and services. So they're at that, looking at it from that level, they are complementary. But I know, because I've had this conversation many times, people will say, well, but you mentioned pricing. Aren't people using task codes to come up with pricing? And my reaction to that is, because obviously I care about this and have done a lot of research, if you look into the task codes, their stated purpose is an e-billing data exchange standard, and they work very well for that. People have tried to then take that and say, oh, let's use this for building project plans, for pricing, and other things like that. And I don't, my personal opinion is they really weren't designed for that. And having looked at this point, thousands of matters tagged with task codes, the codes have not been helpful in coming up with pricing and budgeting. And in one respect, because they lack, they're sort of done separate from scope. What the SALI, approach is to really start at the top, and then future standards. In fact, this came up at the most recent ILTA standards meeting, was people are wanting to do what I call go down the stack and say, in fact, the two that came up were labor, litigation, and M&A work. And they wanted to define segments of, I'll use the M&A example. And the general segments are, diligence, negotiation, and documentation, a very, very high level. And I said, time out, that's not what we're doing. We're not talking about, what are the segments of work involved in an M&A deal. We're talking about defining what M&A means. If we want to go down the stack, that would actually be a separate standards effort. And what would do to pursue that is, a group interested in doing that would have to come forward with, representatives from each of the stakeholders, legal departments, clients, and the providers, show that there is a real need for, standardized codes to be developed in that bucket, and that there is a critical mass of people willing to participate. They would bring that to the SALI board and with a proposal saying, we want to start a new work group. saying that's all successful. SALI board would say yes, and then they would pursue down a similar path that you're seeing here to the matter types. Now, over time, and I would guess that when that group comes forward, they're going to say one of our goals is allowing, the ability to build budgets and pricing for M&A type of work. And so I could see that. And so at that point, you might say, oh, it could conflict with the task codes. It may, but at that point, as I say, we've got good liaison relationships on the task code side. Maybe we roll them into this effort. I don't know. But at this point, I'll go back to where I started. It's a very complementary effort. In fact, one of the ways we ended up here was people kept coming to me, because I do a lot of presentations, saying, how do we figure out, pricing? And I said, well, if it was me, I wouldn't start with tasks. I'd start with types of work. In fact, at one of my prior firms, I made the comment to the managing partner. I said, we don't know what we sell. And she goes, oh, yeah, we do. And I said, well, we know generally what we do, but when we go in our systems and say, I want to see all of the single plaintiff labor matters, we really, it's difficult because there's no real standard. And in fact, I can tell you that at that firm, we had close to 500 different matter type codes. And if you have that complex of a code set, it doesn't really get used effectively. If we had had a set that was based on an industry standard, I'm guessing we would have used them a lot more, and we would have been able to say, oh, we know what we sell. We sell X number of single plaintiff litigations. We sell Y number of M&A deals. So I see it. I guess that's just another value point. Hopefully this helps you sort of put it into perspective relative to what the task codes do and what they're designed for, and that this is a complementary effort. With that, I'll leave you with one final thought. We really want to see more clients get involved. I mentioned Microsoft's involved, Shell Oil is a member, GlaxoSmithKline is involved. We just see that client participation will be critical for the success of this. There is at this point, I think, 10 or 11 law firms that are full-on members, and we have a number of providers that are members. We're really at this point trying to get people involved, so we bring all of those perspectives to the dialogue around this, and that will lead to a successful set of standards that really have a positive impact on the industry. One final comment, I should point out that the two founding entities for this, and I give them a lot of credit for really having a vision and stepping up, are the Legal Marketing Association, the LMA, and the Association of Legal Administrators. After our initial meetings, we'd had a number of associations step up and express interest, but those were the two that really picked up the ball and put some skin in the game, provided some seed money to get this up and going. So we're very grateful for their participation and support of this, and now we see it getting its own legs, but they've been very instrumental in making this work. Thank you again for your time and listening to this, and feel free to reach out. If you go to the SALI.org website, there's more information there, and you can ping members of the team to get questions asked. And of course, you can reach out to me. I'm always happy to talk about SALI. Thank you again, and have a great day.